It is our very great honor to have with us the father of privacy in Japan. I'm gonna let him speak for himself, but he is their main consultant for their equivalent of Congress, the Diet, on all matters of privacy, and they would only let him come here for 2 days. He's so precious to them, so he's come despite the hardship of the long flights, and anyone who knows jet lag, forget it, it's very hard. And so he made a great sacrifice to come here, and as you know, you'll be seeing him tonight when he receives the Louis D. Brandeis Privacy Award for this year. So I'll let you start right away.
Yes.
Thank you so much for coming and helping us and teaching us about Japan and privacy. Thank you so much.
Dr. Bill, thank you very much for your kind introduction. Ladies and gentlemen, I would like to thank Patient Privacy Rights and the O'Neill Institute for National and Global Health Law at Georgetown Law Center for inviting me to the 5th International Summit on the Future of Health Summit. It is a great honor for me to have been given this opportunity to speak the evaluation of privacy in Japan over the past half century, lessons from American privacy law. It's just my history in my research, and I'd like to tell you in detail. But I'm afraid my speech is the contents of my speech will be somewhat unique at this summit, but would like to focus on a comparison of privacy law between the United States and Japan. In Japan, today, the right of privacy is legally protected by courts of justice and legislative measures. Historically, the term privacy seems to have first appeared in Japanese literature in the 1920s and 1930s, but was not recognized to any great extent in the academic world until the late 1950s. Legal scholars, including me, who have researched the development of the right to privacy in Anglo-American and continental law, have tried to translate it into Japanese, but no translation has yet prevailed. In other words, we have been unable to invent a new Japanese word readily acceptable to the public. However, the term privacy, like this, written in katakana, a phonetic alphabet used to write foreign words in Japanese, has become a Japanese word with which almost all Japanese people are familiar today. Around the first lawsuit brought on March 15, 1961, we have discussed how to protect privacy in Japan at the office of the late Professor Masamito at the University of Tokyo. He was my teacher, and I'll refer to him later. I remember we discussed what the cause of action should be with the attorneys for a future plaintiff. This is the front page of famous novelist Mishima Yukio's After the Banquet. Sorry, it's in Japanese, but if I translate it into Japanese, After the Banquet. A prominent politician, Hachiro Arita, former Minister of Foreign Affairs, who was running as candidate of Tokyo Metropolitan Government in 1959, brought an action for invasion of privacy on March 15, 1961, using that term in his statement of claim against the popular novelist Yukio Mishima and his publisher for an unauthorized roman clef entitled After the Banquet on his marital affairs. As a result of this lawsuit, the concept of privacy was brought to the attention of the Japanese public for the first time in history. The benefits of such notions as private lives, personal affairs, and personal secrets, of which public awareness had only been vague, were crystallized into a new household word, privacy. Much research was conducted into the approaches of the American and other foreign legal systems to this concept. And not surprisingly, it was the works of Samuel D. Warren and Louis D. Brandeis, The Right to Privacy in the 1890 Harvard Law Review, and William L. Prosser, Privacy in the 1960 California Law Review, that attracted most scholarly attention. This is the first page of Warren Brandeis' Right to Privacy for Harvard Law Review, page 193. And this is the last page of this article. Here it's not clear. Well, here it's Boston, December 1980, and Brandeis' name is here. This is the picture of Louis de Brandeis. The source is Brandeis, now Saturday, February 20th, 2015. This is young Brandeis. It's about 1890, so it's the time when he wrote a very famous article, The Right to Privacy. Well, this is the first part of this article, that the individual shall have full protection in person and in property is a principle as old as the common law. But it has been found necessary from time to time to define anew the exact nature and extent of such protection. Political, social, economic changes entail the recognition of new rights, and the common law, or in its eternal use, grows to meet the demands of society. Thus, in very early times, the law gave a remedy only for physical interference with life and property, for trespass be et arms. Then the right to life served only to protect the subject from battery in its various forms. Liberty meant freedom from actual restraint, and the right to property secured to the individual his lands and his cattle. Later, there came a recognition of man's spiritual nature, of his feelings and his intellect. Gradually, the scope of these legal rights broadened, and now the right to life has come to mean the right to enjoy life, the right to be let alone. It's a very famous wording. The right to liberty secures the exercise of extensive civil privilege, and the term property has grown to comprise every form of possession, intangible as well as tangible. Well, perpetual fame of the right to privacy have been expressed in many books and articles. So this is one of the examples written by William Prosser. I'll refer to later. it has come to be regarded as the outstanding example of the influence of legal periodicals upon the American law. Here I would like to rewrite this sentence as follows. Not only the American law, but also the Japanese law and all other laws in the world. And then William Prosser's Privacy, which was published 48 California Law Review, the California University Berkeley Law Review, at page 383. This is the picture late Professor William L. Prosser. I visited the University of California, Berkeley in 1974, but unfortunately he already passed away. He passed away in 1972. The beginning of the second paragraph of page 383, Mr. Warren turned to his recent law partner, Luce de Brandeis, who was destined not to be unknown to history. The result was a noted article, The Right to Privacy, in the Harvard Law Review, upon which the two men collaborated. It has come to be regarded as the outstanding example of the influence of legal periodicals upon the American law. Then, in other part, Professor Prosser referred like this. What has emerged from the decisions is no simple matter. It is not one thought, but a complex of four. The law of privacy comprises four distinct kinds of invasion of four different interests of the plaintiff, which are tied together by the common name, but otherwise have almost nothing in common except that each represents an interference with the right of the plaintiff in the phrase coined by Judge Cooley, to be let alone. The word right to be let alone was used by Judge Cooley in the 19th century. Without any attempt to exact definition, these four thoughts may be described as follows. 1. Intrusion upon the plaintiff's seclusion or solitude or into his private affairs. 2. Public disclosure of embarrassing private facts about the plaintiff. 3. Publicity which places the plaintiff in a false light in the public eye. 4. Appropriation for the defendant's advantage of the plaintiff's name or likewise. This classification of invasion privacy have been used in Japan. For example, a textbook on torts by Japanese scholar. It's very useful to understand what privacy invasions are. So at that time, in 1961, I translated the following 17 privacy-related cases into Japanese with my colleagues. I'll skip these cases, but they are very famous cases in some states' courts. We have been discussing how to protect privacy in Japan, and Professor Masamito, my teacher, wrote the book Right of Privacy in 1963. It was before the judgment of the Tokyo District Court in 1964. this is the photo of late Professor Masamito from collected essays in celebration of the 60th birthday. It was published in 1980. I contributed an article on the Privacy Act of 1974, U.S. Act, to this collected essays. I'd like to introduce Professor Masamito. He was professor of law at the University of Tokyo and later Justice of the Supreme Court from 1980 to 1989. He's sometimes called Luis de Brandeis in Japan because Luis de Brandeis appointed Justice of the Supreme Court later. He was written extensively in the area of freedom of speech, constitution, privacy, media law, etc. He received the Order of Culture Award, an imperial honor, in 1999. Professor Ito's book, The Right of Privacy, he was wrote the main parts of his book during his stay at Harvard Law School for a month and a half in the fall of 1961. He referred to many American cases of privacy in this book. He emphasized the necessity of recognizing the right of privacy in Japan. I presume these academic works contributed very much to the first judgment recognizing the right of privacy in torts in Japan in 1964. The Tokyo District Court recognized the right of privacy on September 28, 1964, on the basis of Section 709 and 710 of the Civil Code. It's a codified law of civil law, and awarded the plaintiff 800,000 yen, then 2,200 US dollars in damages, which was at that time the highest award of damages made for either defamation or privacy. In creating the right of privacy, the court declares that respect and protection of individual dignity in a society of mass communications was no longer a matter of mere ethics, but rather a personal interest elevated to a legal right to be protected against unlawful infringement. The court defined the right to privacy as the legal right and assurance that one's private life will not be unreasonably disclosed to the public, and found that the idea was recognized in statutory provisions concerning certain aspects of privacy and guaranteed under the constitutional requirement that all people be respected as individuals. This judgment was welcomed by lawyers, but criticized by the literary community for curtailing freedom of expression. The media has since attempted to respect the right of privacy as a matter of public morality, while continuing to emphasize the importance of press freedom. The general prevailing opinion is that since privacy and media freedom are important democratic interests, the facts of a particular case will determine which interest will be paramount. These are some provisions of Constitution and the Civil Code. There is no express provision protecting privacy in the Constitution of Japan of 1964. This constitution was made under the U.S. occupation immediately after the end of World War II. And most part of the provisions were much influenced by U.S. Constitution. Article 13 of the Constitution provides, all the people shall be respected as individuals. Their right to life, liberty, and the pursuit of happiness shall, to the extent that it does not interfere with the public welfare, be the supreme consideration in legislation in other governmental affairs. The Civil Code was enacted in 1898, very old, but these two sections are still used as it was. Anyway, this is when we discuss how to protect privacy on the other new rights or interests, we usually rely upon these provisions. Then, well, in the 1960s, we have been discussed how to protect traditional privacy in Japan, but in mid-1960s, it was 1965, constitutional right to privacy attracted many scholars in Japan. This is a very famous case, Griswold versus Connecticut. The Supreme Court ruled that Connecticut state law forbidding sale or use of contraceptives violated the right to marital privacy. Anyway, it's a very famous and important decision in the history of constitutional right to privacy. Then, in the latter half of 1960s, we met late Professor Alan Weston's Privacy and Freedom. I bought it, this book in Japan, and the left one is the front page of his book published in the US, and this one is the front page published in the UK. In the United Kingdom, they pronounce privacy, not privacy. I bought it in London. Well, front page is very different. This is a picture of late Dr. Alan F. Weston. Well, this photo from Japan Privacy Center. I will tell you later about relationship with Alan F. Weston. Well, in Japan, the current Personal Information Protection Act was enacted in 2003, and he and some Japanese set up Japan Privacy Center. But after his passing away, the activity stopped. This photo, his smile is very nice here. Alan F. Weston's Privacy and Freedom is very famous, and this phrase is well known. Privacy, the claim of individuals, groups, or institutions to determine for themselves when, how, and to extent information about them is communicated to others. I remember being very impressed by Dr. Weston's idea of privacy when I first read his book in 1965. Needless to say, he is one of the awardees of the Louis D. Brandeis Privacy Award in 2012. Personally, I enjoyed long-term friendship with him. I will touch upon his discussion on the protection of privacy and personal information in Japan later. The next, Professor Arthur Miller's The Assault on Privacy. The left one is a hardcover, the right one is pocket, that's also right, paperback. In this book, Professor Miller defined the right of privacy like this. Of late, however, lawyers and social scientists have been reaching the conclusion that the basic attribute of an effective right of privacy is the individual's ability to control the circulation of information relating to him, a power that often is essential to maintaining social relationships and personal freedom. I remember I met him at Harvard Law School in the fall of 1973. He told me that he had been invited to Japan by the Telecommunications Union in February 1973. He advised me to contact a senator who was interested in privacy and the Commonwealth of Massachusetts, where he had been chairing the Commission on Privacy and Personal Data. Then, in the 1970s, we began to discuss how to enact the acts protecting privacy and personal information. So the Privacy Act of 1974, U.S. Act, is very useful for us to understand what the privacy is. And long title is very long, and this is 5 USC section 552A, records maintained on individuals. 5 USC section 552 is public information, which is a Freedom of Information Act. I have been also involved in drafting Freedom of Information ordinance at the local level first, and next at the national level. The Privacy Protection Study Commission issued, set up by this act, issued its final report, Personal Privacy in an Information Society, in 1977. I bought this report, but I looked for it in vain, because I have lots of books in the corrugated boxes. I have more than 100 corrugated boxes, so it's very difficult to find this report. But I found this very thick documents, Legislative History of the Privacy Act of 1974, or 1,458 pages, and it's very old books now. Then Privacy Journal. Robert Smith have been publishing Privacy Journal. I understand Privacy Journal is one of the sponsors of this summit. I don't know, remember when I began to subscribe the Privacy Journal, but this is the Privacy Journal index from 1974 to 1984. And also, I bought his book, many his books, and this is one of his book, Privacy, How to Protect What's Left of It, published in 1980. He visited my office in Tokyo on August 6th last year. This is in front of the signboard of Specific Personal Information Protection Commission. We usually use the signboard from top to bottom. Well, then this is my own book, The Contemporary Privacy, published in 1980. I traced the history of American privacy law from Warren and Brandeis, the right to privacy, to the late 1970s, including the Right to Financial Privacy Act of 1978. I proposed legislation on privacy protection both at the national and local levels on the model of the OECD, Organization for Economic Cooperation and Development, 1980 draft privacy guidelines, draft recommendation of the Council concerning guidelines governing the protection of privacy and transborder flows of personal data, which I had obtained prior to its adoption on September 23 of the same year. My book was published in August 1980. This book contributed to enacting personal data protection ordinances at local level. Well, then this is another book, Information Age and the Law, published in 1983. It was the textbook of Japan Broadcasting Corporation, NHK, TV program. In the fall of 1982, I was asked by the Japan Broadcasting Corporation, or NHK, to appear on TV as a speaker in a 26-part series on information society and the law from April to September 1983. One program was 45 minutes. I took advantage of this opportunity to spread the idea of freedom of information and privacy. I allotted 7 programs to freedom of information and 6 to privacy. I referred to Warren and Brandeis' right to privacy and American privacy cases and legislations. The audience was probably over 1 million. Then this is my book published in 1988. I updated the contents, including American privacy law. This book went into more than 20th printing. One of the best sellers in the world of law books. Other acts relating privacy of the United States very important for us to understand how to deal with other issues of privacy. For example, Fair Credit Reporting Act of 1970. In mid-1990s, we began to discuss how to protect credit information. we refer to the Fair Credit Reporting Act of 1970 very often. And Privacy Act of 1974, anyway, I'll skip to the next page. Then late Dr. Alan Weston's interest in Japanese legislation. As I told you, I enjoyed a long friendship with the late Dr. Alan Weston. Well, this is his birthday and the date of death. Recently, I was asked by the Japan financial newspaper, Nikkei Shimbun, to write some friendship relation with some other persons. Then, anyway, I wrote it in connection with his long friendship. Then he had a special interest in privacy and personal information protection in Japan. I invited him several times to Japan and we discussed privacy issues. His journal, Privacy and American Business, Volume 10, Number 8, November 2003, ran a feature on consumer privacy in Japan and the new national privacy law, implications for the U.S. business and implications for Japanese companies. He asked me to check his draft. It's very burdensome work for me. Well, he employed a Japanese staff to translate Japanese laws and newspapers into English. But legal technical terms are very difficult to translate it. So when I read his draft, I tried to rewrite almost all his draft. So anyway, well, the contents is like this, but please look at this cartoon. The front page of this journal carried the following cartoon. This is Omnibus Data Protection EU model and sector privacy rules USA. Which way we will go, we have been discussing at that time. So, EU, our European Union and the government of the United States told me which way you would like to choose. So anyway, I had to choose a third way, or Japanese way. So this is the Japanese way. This young man wearing yukata going to Japanese way. So this cartoon is very important to explain the method of protecting personal data in Japan. Well, Alan Weston said like this, in Japan's middle way, the road ahead. He wrote that rather than adopting either the US or European style approaches to privacy and data protection, Japan's Personal Information Protection Act of 2003 represented middle way. So we have had lots of lessons from American privacy law. To summarize, the background of the right to privacy, the traditional idea of privacy, the right to be let alone, the law of privacy comprises for distinct kinds of invasion of for different interests of the plaintiff. The modern idea of privacy, a more active meaning, the right to control one's personal information. In other words, deciding for oneself when, how, and to what extent one's personal information can be communicated to others. And also, we have been learning lots of lessons from your legislation. This is the legislation of the United States concerning privacy. Lastly, I'd like to talk about the recent development of privacy and personal data protection in Japan. One of the recent notable developments in Japanese data protection law was how to protect personal information in a number system. In the United States, a social security number was introduced in 1936, but Japan, numbering system or unified numbering system began to be discussed in late 1960s, but the oppositions were very strong and it was very difficult to introduce number system. So the Working Party on Personal Information Protection, which I chaired, began to discuss the system of protecting privacy and personal information in February 2011 and submitted a proposal in June 2011. Those proposals were implemented in the Number Use Act of 2013. I'd like to refer to medical information. How to deal with health information or medical information closely related to patient privacy has been discussed from the outset at the subgroup and the working group on personal information protection. Various opinions have been expressed, and one of the prevailing ones was that any attempts to link my number or individual number with medical records must proceed with extreme caution. My number is dubbed instead of individual number. It's a nickname of the individual number. The Japan Medical Association has voiced concerns regarding the notion of linking my number with medical records. And the Ministry of Health, Labor and Welfare will introduce a separate medical ID for information relating to medical and nursing care. This is the outline of the system of information protection in Japan. It's very complicated. General law, there are 3 general laws. One is Act on the Protection of Personal Information. This act has a provision, something like basic law or a policy, and also the provisions protecting privacy and personal data in the private sector. The next one, Act on the Protection of Personal Information held by administrative organs, and also Act on the Protection of Personal Information held by independent administrative agencies, etc. In addition to these, there are local ordinances for both public and private. In Japan today, there are about 1,800 local governments. they have their own personal information protection ordinances. So sometimes the definition of personal data differs from the local government to local government. So it's very complicated. Anyway, well, recently we discussed to integrate these ordinances, but at this moment it is very difficult to integrate. So the new act which will be passed hopefully this weekend, the day after tomorrow, I hope. Well, so it is the most difficult time for me to absent from my office because legislative process in Japan is very different from yours. The cabinet usually drafted the law and submitted to the Diet. So I'm one of the officers now of the Japanese government. So I'm responsible for responding to questions raised by the member of the Diet. So being absent from my office will be scolded by the government also, as well as the members of Diet. Anyway, revision of the Personal Information Protection Act will pass the Diet toward the end of this weekend. New Personal Information Protection Commission. Now, specific Personal Information Protection Commission we call. I sometimes I'm asked why specific prefix to the Personal Information Protection Commission. Specific means using numbers in administrative procedure related to social security, taxation, and disaster management. It's a very limited area. So we usually use, in this case, specific information or specific personal information. So anyway, if the bills to amend the existing laws pass the Diet, my commission will be just the Personal Information Protection Commission. And I will be the first chairman of this new commission, which will start on January 1st next year. Anyway, I will be very busy dealing with these issues. Anyway, over the past 30 years, I have advocated establishing an independent data protection authority to guide and supervise both public and private entities for the proper handling of personal information. So, independent data protection authority will be established first time in history in Japan next January. The government of Japan will realize my dream of setting up an independent data protection authority. I also engaged legal research on privacy issues for over half a century and actively participated in the development process of all acts relating to personal information protection and privacy. Based on these experiences, I will continue to make great efforts to achieve our mission of striking a proper balance between utilizing personal data, big data, and protecting personal privacy and personal information, including patient privacy. Thank you very much for your kind attention.
Thank you. Thank you so much. Wasn't this an absolutely wonderful and enlightening presentation, not only about the history of privacy in Japan, but contrasting with what's going on in the United States? This was brilliant and very welcome, most enlightening. Thank you so much. Thank you so much for, and I didn't realize your big bill is about to pass this very weekend. So once again, thank you so much. We knew this was an imposition for you to come, but we are incredibly